Welcome, everyone. I'm Sarah Green Carmichael, an editor with Bloomberg Opinion, and I'm here today with Harvard Law professor and Bloomberg Opinion columnist Noah Feldman. We're going to be talking about the Supreme Court's ruling in the affirmative action cases today. Noah, thank you so much for joining us.
Thanks for having me, Sarah.
Can you just start by just quickly recapping what is in this very long and dense Supreme Court ruling?
Yes, there are 240 plus pages of it, but the bottom line is clear. The Chief Justice, writing on behalf of six justices, so a total of six, all the conservatives on the court, struck down race based affirmative action in higher education admissions decisions. And little room for it to be in any way, shape, or form. And that marks a kind of victory for the conservative legal movement, very focused on for nearly a century, namely to interpret the Constitution and federal anti-discrimination. A university can't any longer say that racial diversity in the class as a whole is a legitimate goal of how it admits people.
My understanding of affirmative action programs as they existed before this ruling was that race was just one of many factors that a school would use, that it was maybe a thumb on the scale, but it wasn't determinative. Is that true? Is that not, does the court basically say on what grounds is that not okay anymore?
Since 1978, been permitted to higher ed in a to consider race as one factor as part of a holistic admissions process in which the racial diversity of the overall class is treated and was treated right to take into account. Now, critics of this have consistently tried to argue that race was more than that, that it played an important and even determinative role in some admissions cases, and the universities have pushed. The court here didn't take a definitive stand on that, but it did chart, which had been brought in the lawsuit against the university, that showed Harvard admissions broken down by racial group over a period of roughly in the aughts and 2010s. And just look at the numbers, which changed very little from year to year, and said, given this, it must be the case that Harvard was illegitimately taking account of. Of course, the university has a different view and had that below, and university, and not with the position of the people who are suing the university, but this is a case from the Supreme Court, so it's the very top. So when they say that, it becomes the law, and we would now have to reinterpret that data in future cases. Again, out here.
Mm-hmm. My understanding is that the Supreme Court based this ruling in large part on the 14th Amendment. Isn't that an amendment that was supposed to help right the wrongs of slavery?
Yeah, this is the fascinating and in some ways counterintuitive story here. So the 14th Amendment was enacted in the immediate aftermath of the Civil War. It came after the Amendment, which abolished slavery based on race. Also, the 14th Amendment established equal protection of the laws. The 15th Amendment said that black people, black men at the time, were constitutionally authorized. So it was part of this troika of amendments that were designed to the old system of slavery in the United States. The Supreme Court acknowledged, even the majority acknowledged here, the 14th Amendment was quickly, because in its aftermath, segregation emerged effectively to replace slavery. And the court acknowledged that that was wrongful, and it acknowledged that that generated a long period of time, the better part of 80 years, in which segregation existed in the United States. But the court said that we realized that after Brown against Board of Education, that equal protection of the laws should be interpreted to mean that the Constitution must be colorblind. Of the view that was advocated already from the beginning, wanted to create greater equality between the races. And that argument is articulated in this case by Justice Sotomayor and Justice Jackson in their dissents, basically says the point of the 14th Amendment was never to be colorblind. It was to ensure, and on the backs of hundreds of years of slavery, followed by nearly a century more of segregation, it makes no sense to interpret the that the government be blind, or in this case, private universities via anti-discrimination law, be blind to race. But the court came down on the other side of that and gave a pretty definitive. It's now the law in the United States that effectively the government and private institutions can't take account of race in the university outcome.
One of the things that surprised me a little bit when I was working on your column with you is that the initial headlines I had seen out there were sort of like Roberts narrows affirmative action. But your column very strongly makes the argument that affirmative action as we knew it is gone. Why do you think that some people might be thinking that maybe this isn't the end? Maybe there's just sort of new rules in play?
Well, write his opinions as though he's not met, because he wants headlines that say not Supreme Court engages in conservative constitutional revolution. And to his credit, in some cases, he really is trying to follow precedent. This is a case where he's foursquare with the other conservatives, more radical than he, but on this issue, he's very radical himself. That there are only a tiny number of circumstances into account. For example, in a prison where on a temporary basis you separate prisoners by race in order to quell a riot. That's circumstance. It's not a systemic solution to social problems. So I think it may be that people were just reading. This always happens. It comes down and people want to put up headlines right away. So I think that's probably the explanation. The other thing is, and this is not about affirmative action, but Roberts, that if a student writes an essay application as part of an application where the student says, I'm black, discrimination in my life, it's perfectly permissible for the university to consider, provided that the racial tie to the individual accomplishments or actions or life of that individual student. Said, let me be very clear, this is not an invitation for the colleges to recreate their current affirmative action as a tool. So don't let that happen. And in response, could still consider an essay like that. Justice Sotomayor in her dissent, lipstick on a pig, which is not a very positive step.
Indeed. Is there anything else in the dissents that you saw that sort of struck you as noteworthy?
There's a lot. Justice Sotomayor's very, very thoughtful dissent not only talks about the history of the 14th Amendment in great, it really tries to show that affirmative action as it's been used in higher ed is working and works well and has tremendously social results. And she actually pointed to the fact that current Supreme Court justices who are people of color, all of whom graduated from, to say that that's a good thing. We ought to be happy about and proud of. So she really offered a full sociological and other defense. Justice Jackson, for her part, really cut deeply into the issue of ongoing outcome disparity between black and white people in the United States. And she invoked lots of scholarly literature, lots of statistics, all of which show, in I think terms that no reasonable person could disagree about, the ongoing effects of the slavery, formal segregation, and then all the informal discriminatory mechanisms, from redlining to the design of social programs, that have rendered African Americans much economically poorer and with fewer access to cultural capital resources like fancy higher education than white people. And Justice Thomas was sufficiently bothered by her opinion that he really went after her in a separate concurrence of his own.
Yeah, could you talk a little bit more about the dispute between them? Because this is the first time that we have had two Black Supreme Court justices serving on the court at the same time and disagreeing on a racial issue.
It is, and that's itself, I think, historically noteworthy. And among other things, no matter who you side with, it does show that there are different people who are both Supreme Court justices, so they have that much in common, who differ very questions. Thomas's approach was extremely personalized, very unusual. He doesn't refer to the dissent or the dissent as Justice Jackson's dissent, and then he says Justice Jackson herself. He categorizes her approach, essentially accuses seeing racism as the inexorable fate of all. And she, in her own defense, and I would say she kept it classy, she kept it to a single footnote of really moderate tone, said Justice Thomas is responding to a dissent that I didn't actually write, to something that's not actually here. Her view is, of course, not that the effects of race are measurable, but that they are real and that they are ongoing and that they haven't been fixed. And again, I think it's hard to say that that, as a factual matter, isn't just objectively right. Though, is trying to sort of group her alongside a broader sort of strand of conscious thought that regularly wants to draw attention to the ongoing effect history of racism and of slavery and segregation. And that troubles him very much because it's inconsistent with his colorblindness approach to the Constitution. So he says things like, I should care about her statistics that show great disparities of wealth. There are some black people who succeed nevertheless, and some white people, which is a kind of denial of the whole reality of statistics. It's a kind of point of view as who cares what the statistics say? Who cares what overall effects are? I have that refutes that. It reminds me of that old line that the opposite of data is not anecdote. But that.
Yeah. In terms of some of the impact of this decision, you wrote when the case was argued that the impacts would be far-reaching. Could you maybe walk us through first what the likely impact is on the universities themselves?
Let's start with the universities. I work at Harvard University, and in our column, and we came on here to talk about it. I already had a long email in my inbox of the senior administrators in the university sort of gently acknowledging that Harvard lost its case and saying that Harvard is still committed to diversity of perspective and viewpoint, but assiduously avoiding using anywhere in that account. So what that means in practice is that we're at the first stage of a moment where the universities are going to have to really read their core picture of what they're doing in admissions. They can still say that they care. They can talk about socioeconomic diversity. They can give a special preference to first-generation college students or to people from economically disadvantaged backgrounds, or individually to have overcome substantial kinds of discrimination. But they're no longer going to be able to try to create a class that is statistically balanced on the basis of race. And if they do, they're going to get sued by the same people who sued. And we now know that the Supreme Court is going to be sympathetic, redound through the lower courts. So what's going to happen is that the universities are going to try mechanisms to create diversity in the class, specifically referring to race or looking at race, and they will succeed in doing that, but they will be challenged in that practice. So if you compare it to what happened, say, at the University of California adopted a state constitutional amendment by referendum action, or at the University of something similar happened in Texas, what you saw was a substantial reduction in the number of Latino students admitted to the class. And that's the most probable outcome here. Selective colleges broadly, but there will be pushback. They will try to do otherwise. A lot of ongoing litigation around the efforts that they do in fact undertake. Level, it's an interesting question to ask. Diversity will still continue to be the master word in the college trying to produce, because diversity includes viewpoint, and viewpoint diversity includes preferences to, say, conservatives or evangelicals or other people. The university may want to have some of them around, but it may not want to have a lot of them around. And so diversity, if it's no longer serving its true original function, which was to allow racial diversity. So The idea of diversity grew out of the racial diversity. And the consequence of that was for the ideology of diversity to be adopted more broadly. Now that it can't racial diversity anymore, it's an interesting question to see how long will the universities continue to see diversity as their master or ideology.
I'd love to get your take also on what this means for companies. And I will be a little bit transparent here when I say when we were discussing this case the end of last year, you said to me many times that there would be a profound chilling effect on corporations. And I was skeptical of this. But now it's here. And I have months later come around to your point of view that that seems very likely. So you can tell us all why you were right and why you saw this coming months ago and had to work so hard to convince your editor that she was wrong.
Well, first of all, I'm glad that are getting a little insight into how the editor-writer relationship works. It's my job to convince you, Sarah. And we have a good long piece still, I think, because we drafted it up, but we never published it. So uh, here's the bottom line. Technically, affirmative action would be governed by Title VII of the Civil Rights Act, which is about workplace discrimination, whereas higher ed admission, the Civil Rights Act, which is about higher education. Technically, this case is about Title VI, not about Title VII. Title VI and Title VII get their inspiration from what the Constitution is interpreted meaning. And in this case, the Supreme Court interpreted first the Constitution, and second, Title VI, and treated them as effectively identical to each other. So that's a strong signal that when it comes to discrimination, part of the Civil Rights Act, the court can apply the same interpretation of the Constitution as colorblind and apply it to the statutes. It's going to mean is that if you're a corporate employer and you draw on racial diversity as one of your objectives in the work, short order, that is going to be held first by the lower courts and very possibly ultimately by the Supreme Court to be unlawful as well. Now, not all corporations, in fact, many don't say that when they're seeking diversity, they're seeking racial diversity. They have other formulations that talk about different backgrounds, different experiences. But the same people who brought you the lawsuits here are also suing already and will continue a range of large corporate employers using the numbers of their hiring to allege de facto racial discrimination. And so, if I were, running human resources at a major bank today, I would look at the chart that the Supreme Court used to look at Harvard's admissions and said, look, the same number of Asian Americans and African Americans and Latinos and white students every year. That's reason to think that they're discriminating on the basis of race. And I look at our numbers, can the same chart be made with respect to us? And if it can be, it's going to be used in court cases against us. And so that means that even lawyers who don't say that they're taking account of colleges did openly say it, are now going to have to prepare to defend their if they themselves have been hiring effectively a race. Now, there may be cases where this is litigated in detail and where some employer stands firm and litigates it and wins. But, the universities are in a different position than corporate employers. They don't nonprofits. They can afford to fight and lose, and the next day there's no major consequence, for them in an economic sense. They'd be much more inclined to settle lawsuits against them if it looks like they're running well against them. And so I think there is going to be a real change. And that's at the level. A second component is to the universities rely on the graduates of selective colleges and universities. They're going to have an applicant pool. So that's going to mean they're going to have to look more broadly. And that's very significant for certain kinds of firms. Hire people from the fanciest schools. Be relevant. And then last but not least, there's that word diversity. We've seen chief diversity officers or appointed at lots of major American companies. I think it's very possible that the language of diversity is over time, not today or tomorrow, but over time. And how many firms no longer call that person the chief diversity officer, and every chief diversity officer's his or her title over the next several years. In some cases, those folks may even have to find new jobs, as our culture of how hiring can new cast.
Well, clearly a really fundamental and sweeping decision here, despite the fact that it maybe initially sounded narrow to some people. The other issue here that we don't normally go into in a Supreme Court case is the footnotes. Like in a decision of this length, it's unusual for so much.
Sometimes we have no choice.
Sometimes we do, but in this case, there's a footnote that has a lot of people confused, which is a special carve out for military academies. Could you talk about that and maybe like how does that make any sense at all?
So, in footnote 4 of the majority opinion, Chief Justice Roberts said, "For us are not military academies, so this affect them, and there may be," he said, maybe, "there may be special considerations in the case of the military." So, what does this mean in practice? What it means is that summer and fall, when the military academies do their admissions, they still could count of racial diversity. It's basically inviting a separate lawsuit to be brought against. Somebody will sue them, although that seems relatively unlikely. Usually somebody sues. But he's basically calling for a separate evaluation whether the rationale for racial diversity might be different in the case of the military academies. Now, why would it be? Well, both in the 2003 Supreme Court cases about there were friend of the court, very senior military officials, usually ex-military officials. Essentially, look, the military academies is where we train a lot of the officer corps. If we have racial diversity in our officer corps, we're not going to be able to military effectively. And what the Chief Justice is signaling is that he, at least, is open to considering that argument as powerful. He hasn't, and he certainly hasn't bound the other conservative justices. Remember, it would just take 5 of them. You don't even need the chief to reach the conclusion that this applies there as well. I think you can say with near total certainty that Justices Thomas, Gorsuch, and Alito would be very unsympathetic to the argument that the military academies were somehow different. For the Chief Justice, harder to say for Justice Kavanaugh, and unclear what Justice Barrett would think about it. But the key point is that that is going to have to be litigated and dealt with separately, which is probably a relief to the folks who do admissions, military academies. But it does portend ongoing litigation against them, and that probably is not a relief to the lawyers who places and to the part of the Department of Defense that has to administer.
Okay, that's helpful. Thank you. In terms of admissions at the other universities, non-military academies, which is most of them, I guess the other side, the plaintiffs in this case, have been arguing that, look, admissions at these universities are a zero-sum game. If one person gets in, another is excluded. And they have made the case that, in their view, white students and Asian American students are being unfairly excluded. And I want to ask you what you make of that, both intellectually, but also as someone who is a father of children who are of Asian background. What are your thoughts on that argument?
So, first thing I would say is that argument won today. Chief Justice Roberts literally used the word zero. So that's if you make an argument enough in public and eventually the Supreme Court adopts it, that's called winning in the context of legal. That's now law, for better or for worse. In my view, this is a very delicate and complicated issue because it's true that admissions number of people who can be admitted to the class. On the other hand, when you consider each in a highly individualized assessments process, which is what you have at the most that can afford, an expensive admissions office, It's not the case in terms of racial trade-offs, right? I mean, the numbers have to add up percent. Yes, that part is true. But the individual people have different criteria, that it's not that they're genuinely interchangeable. Now, if you delved very deeply into the evidence that came out in the lawsuit, there was some evidence to support the idea that Harvard was discriminating against Asian American applicants, although the district court judge, and that most of the discrimination came from the non assessment, the personality, as it were, assessment, being letter writers, not the people who worked at the university, but the people who worked at the high schools who were writing the kids, and that was coming through in this initial assessment. I take that seriously. That's a concern that everyone who cares should take into account. And it was a tricky issue for the district court judge to deal with. And since then, Harvard's actual admissions numbers for Asian American kids have gone up pretty substantially, which some of it does suggest that the admissions officers decided to bend over backwards to make sure they weren't engaged in that. You know, my own view is that we want to, look, I did not support the outcome in this. We needed and still needed to have affirmative action, Latinos in particular, to assure depth of the educational opportunity for students, but more importantly than that, really, in my view, to assure that are reflective of the United States in a broad. You could do that without discriminating against Asian Americans. You would just have to accept that there would be students, and maybe there would be fewer white students under some circumstances, and maybe that's a trade-off that's just totally fine. So, I don't think I think the idea that there was a kind of inevitable conflict was probably not, strictly speaking, true. But again, that is now a historical consideration, and, admissions are going to happen starting this fall in a new way, and we're going to find out how it plays out. It's a whole new world.
Yeah. I guess the other argument that has come up in this case a lot is that that quotas are not allowed, and there was effectively a sort of silent quota because the universities kept admitting sort of the same percentages of students by race. And the history of quotas in higher education is pretty ugly, as you know. I mean, the first quotas were actually designed to keep out people who were qualified, and in that case, Jewish people. Do you feel like that is something that is a parallel that holds any water in this case now, or is that something that is an interesting historical parallel but doesn't really tell us anything about where we are today?
Well, it's true that in the 19th explicit quotas in admission at a lot of colleges on based on religion. Really, it was to keep out urban Jews who were doing well on standard Latin tests that got people into college. Harvard, the ideology of diversity was originally developed also as an alternative way to reduce the numbers of Jews. That argument, and the court acknowledged it today. Some of the acknowledged it, and that's an ugly history without any doubt. To the or consciously or unconsciously putting an upper limit on the number of Asian American applicants, that would look also like a quota, and it would also be wrong in a fundamental way. College admissions is a bit of a game, and there are rules to the game, and if some group of people are disproportionately succeeding under the rules of that game, it's lawful to have a quota that blocks them from admissions on those grounds. I don't, however, think that that's really what was going on in the case. The kind of rhetorical argument that the opponents of affirmative action were making, because there's really no reason that you couldn't have plenty of racial diversity in a class and still not have quotas for every group. And so, that's the sort of mistaken piece of, to some extent, carried the day, and it affected the justices. That's the way the game of constitutional the justices, that becomes a law, and that's where we are now.
Yep. I can't let you go without asking you for like the big picture here. Last term, the court had a number of big decisions on hot button issues: abortion, guns, religion. This term, it's affirmative action and maybe religion again. What is happening here? What's the sort of big picture as the court overturns decades of precedent on all of these issues?
We're in a conservative constitutional revolution, and it's a consequence of the position of the Supreme Court, and there were multiple into that. They included Mitch McConnell stonewalling Merrick Garland's appointment. They included the fact that Ginsburg did not step down despite being very ill when Barack Obama was president and the Democrats had a Senate majority. And they include, maybe more than anything else, the fact that Donald Trump was president of the United States. You know, he got 3 judicial appointments in his tumultuous 4 years, disproportionate number, and it's not pure luck because one of them came as a result of luck plus. But the reality, that's a foundational shift in the character of, and it's having major, major, major consequences across the board. And you and I may be back here tomorrow potentially to talk about one of the remaining cases before the court, which is about the question in Colorado has, under the free speech part of the First Amendment, to refuse to gay couple getting married. So the court is not done, and one by one hitting the big ticket issues that the movement has wanted for the better part of half a century, and living in right now.
Well, Noah, thank you so much for walking us through it today. Thank you all for joining and watching. I'm Sarah Green Carmichael, and I'm here today with Bloomberg opinion columnist and Harvard Law professor Noah Feldman. Join us again for more analysis.